Social worker Rachel Mead this week won her case that Westminster City Council and Social Work England discriminated against her when she was suspended for sharing gender-critical views. This is a real landmark case, and I'm going to be discussing this today with two guests. I'm joined from Glasgow by Michael Foran, a lecturer in public law at the University of Glasgow, and here in the studio by the family law barrister Sarah Phillimore. I'm going to come to you first, Michael. Can you give us some background to this case and why it is so significant?
So Rachel Mead is a social worker. She'd been working with Westminster City Council and been regulated by Social Work England for 20 years. She had a private Facebook account that had about 40 people as friends on it, so only those 40 people could have access to the posts that she made. Over the course of a year, when the UK government was soliciting feedback from people about potential reforms to the law on gender recognition, she posted a few posts, including posts calling for reform to the law in relation to men who identify as women in prisons, or particular posts in relation to males and female sports. She had a member of her Facebook group identify these things as extremely offensive and made a complaint to Social Work England.
So one complaint was all it took for her to be suspended and investigated and at least now acquitted. Can you just fill us in, Michael, where does the law stand on this? Is she not entitled to post her private opinion about the need for single-sex spaces on her private Facebook page?
Oh, more than that. I mean, she's entitled to voice these opinions publicly. She's entitled to voice these opinions in her place of employment, so long as it doesn't constitute a breach of the employment law that she'd be subject to. I mean, what happened here was this was a woman who was voicing a political view on one side of a political debate, who was subject to an egregious example of harassment. I mean, it's really shocking, I think, that this case even got to where it got. I mean, a potted plant would have won this case. This was an open and shut example of harassment. So, yeah, it's not just that she can voice these views privately. She's perfectly entitled to, under her human rights, to voice them publicly as well.
Well, I'm going to bring Sarah Phillimore in on this because I'm struck by this. I spoke to Toby Young from the Free Speech Union recently. They're taking on so many cases like this when gender-critical individuals post something and then they're harassed by their employer. I know that the Free Speech Union helped the fundraiser for Rachel early on. So why are more and more people having to do this? Why are employers not realising that there's laws against this kind of thing?
It's very curious. It shows that I was naive about lawfare. I thought that all we needed was a few big wins and we'd stop this in its tracks. We had those big wins with Maya Forstater and Harry Miller, both in 2021. But
Maya Forstater's case, we should say, that established in law that to say that there are two sexes and that you cannot change sex, that is a protected belief.
It's worthy of respect in a democratic society.
Right.
So that overturned the first instance decision, which said it wasn't. So I thought, hurrah, in my naivety, we've done it. We can all get back to business. We can get back to focusing on our time and energy on really important things. I was utterly naive, because what has happened is, I suspect, with the input from lawyers who are guided more by ideology than understanding of the law, employers, organisations are simply ignoring those cases. I represented Rachel in the Fitness of Practice Tribunal hearing. I was shown a statement of case from Social Work England, dated July 2022, that said a gender recognition certificate changes a person's sex as a matter of biology. Now, I asked the tribunal to make it very clear that this was wrong, and not only was it wrong, the Employment Appeal Tribunal in Forstater had set out in a number of paragraphs why that was wrong. A GRC creates a legal sex, nothing more, and that legal sex can be disapplied when it's for a legitimate and proportionate aim. So it was quite clear that Social Work England and those advising them had not bothered to read the key judgment. And having embarrassed themselves and withdrawn from opposing a sanction on Rachel, then Social Work England and Westminster continued in the Employment Tribunal, and we've seen the outcome of that.
That's so interesting. Michael, can I ask you about that? Because I think what Sarah's alluding there is this idea that there are activist lawyers attempting to misrepresent the law. Have you found this?
Yeah, I mean, I think it's a very strange area of law, because it's very rare that you would have barristers or solicitors or people who work in this field be willing to misrepresent the law like this. But the only explanation is that these people are either incompetent or they're misrepresenting the law. And I think, what we're seeing here is a real, I think, culture war that's happening that's resulting in particular activist lawyers. And I don't normally like the phrase activist lawyers, but in this context, I think that's the only way that you can describe how some people are behaving here. Because, yeah, as Sarah says, I mean, this case shows that the lawyers here just either didn't understand what the ruling in Forestarter said, or were purposely trying to get an employment tribunal to overturn or ignore a decision of the Employment Appeal Tribunal.
And that's incredibly worrying. But, Michael, surely, I mean, I often think of lawyers constantly are arguing about the meaning of the law, how the law ought to be interpreted. So what's different about this exactly?
Well, I think in this context, I mean, there are circumstances where there are reasonable points of disagreement throughout all of the law here. But, for example, the claim that the Forestarter decision only protects belief but doesn't protect your ability to manifest your belief, to speak about your belief, to voice your belief, that is just flatly incorrect in law. And no lawyer who knows anything about religion or belief discrimination would ever make that kind of claim. What we would say is that there are certain circumstances when manifestation is not protected. But what happened in this case was that the tribunal was abundantly clear that that does not apply to merely voicing the views that Rachel voiced or to expressing support for the causes that she supported. And in fact, we had, I think, a really important ruling from this tribunal that said Social Work England and Westminster City Council describing her voicing of those views as transphobic itself constituted harassment. So it was an act of harassment to describe what she said as transphobic, because the law is quite clear that she's perfectly within her rights to express those views, and those views are not transphobic according to the law.
So, Sarah, just finally then, I mean, it's perfectly clear that the judgment in this case has even gone so far, as Michael says, to say that this was a form of harassment. So surely this should put an end to it now, shouldn't it? This isn't going to happen again?
I wish I could believe that, but I note what was said by Sarah Newman, the Chief Executive of Westminster City Council. There was a recent article in The Times. Another social worker from Westminster has come forward to say that there is a culture of fear about raising issues when they're presented with children who are gender incongruent. And Miss Newman said, no, nothing to see here. We don't have any of these cases, and when we do, we investigate them thoroughly. Somebody this morning sent me screenshots of a blog that she'd written talking about her trans-identifying stepson wearing dresses. I think Helen Joyce has made this point, and it's a good one. A lot of the people pushing this, I think, are motivated by their love and concern for people who are near and dear to them, which is very understandable. But it doesn't help the rest of us who are then subject to what are clearly unlawful and discriminatory policies.
But surely Sarah Newman must accept the judgment of the court.
Well, you say that, Andrew, but Social Work England managed to dodge that by not even apparently reading the judgment in Forestarter. I think I heard Cathy say to you, the roots of this go very deep. They do, and I'm afraid the deep roots bring with it a deliberate turning away from what the actual law is, aided and abetted by a small cabal of activist lawyers who will reassure these people, of course you're right. There's no right to manifest these disgusting beliefs. They must stay in people's heads. People were still saying that after Forestarter, and I'm afraid my money is on they will continue to say it after Mead, and we will not have seen the end of these cases.
Wow. Well, Sarah, I have a feeling we'll have to have you back on the show because this isn't going anywhere soon. No. Michael Foran and Sarah Phillimore, thank you both ever so much.